Hope I am audible.
Yes,
Oh,
you are audible.
okay. Thank you very much. Thank you very much.
Nidhi?
Good afternoon, everyone. I'm Nidhi Prakriti, and today I have the immense pleasure of welcoming you all to the inaugural ceremony of Chanakya National Law University's Chanakya Centre for Alternative Dispute Resolution. Alternative dispute resolution, as we all know, is pivotal for every legal curriculum as it is one of the solutions of the failure of traditional dispute resolution, which is seen time and again. The skills that are involved in ADR methods are not only for amicably resolving the disputes and disagreements, but these are life skills which are needed for all of us. Our center wishes to bring a positive change in the view of the society regarding disputes and disagreements, that is, as an opportunity to imbibe the skills of active listening, understanding others' point of view, discussions, empathy, rational thinking, and community interest. With this vision in our minds, I would like to invite our faculty coordinator, Mr. Rishikesh Manu sir, to kindly welcome our guests for the day. Sir.
Thank you, Nidhi. Honorable Justice Srimati Mridula Mishra, Vice-Chancellor, Chanakya National Law University, Mr. Ratan K. Singh, Senior Advocate, faculty members, dear students, and everyone present in this ceremony. I welcome you all at the inauguration ceremony of the Chanakya Centre for Alternative Dispute Resolution. The last few decades, the alternative dispute movement has gained almost universal recognition. It is now a first choice for many to resolve their dispute. The idea behind the center is to promote the academic research in the field of ADR and develop the ADR culture among the students. Here we have with us two very distinguished guests. I'm extremely delighted to welcome Honorable Justice Srimati Mridula Mishra ma'am. I can't think of a better person to inaugurate this ceremony than her. She was a practicing advocate. She has been the judge of the Patna High Court. She's a very successful arbitrator, and also is the Vice Chancellor right now of the CNLU. It is a matter of pride for us that Honorable Justice Srimati Mridula Mishra is our Vice Chancellor. Under the visionary and dynamic leadership of Vice Chancellor ma'am, CNLU has achieved new heights in almost every sphere. Establishment of this center was not possible without constant support and guidance of her. Thank you, ma'am, for everything, and I welcome you in today's inauguration program. It is a moment of extreme pleasure to welcome the chief guest of today's ceremony, Mr. Ratan K. Singh. Mr. Ratan K. Singh is a senior advocate and a leading arbitrator of this country. Mr. Singh has represented parties in complex, high-value domestic and international arbitrations. He is also associated with many national and international organizations. He is the only Indian to receive a fellowship from the International Academy of Construction Lawyers. He maintains a close connection with academics also. He takes classes on construction law, international arbitration, and other related themes. And it's also a matter of pride for us that he belongs to the state of Bihar. So thank you, sir, for accepting our invitation. And I hope that you will guide us making this center as one of the important centers in the state of Bihar. I also like to thank our registrar, Mr. Manoranjan Prasad Srivastava, for providing the support in the establishment of this center. I would also like to thank my colleague, Mr. Kumar Gaurav, Mrs. Susmita Singh, and Mr. Vijayan Sinha for their cooperation in the establishment of this center. In the end, I would give my regards and appreciation to all the students who made the center a reality. To be honest, without their support, without their hard work and dedication, the center would not have come into existence. The team led by Madhura, who is the student convener of the center, and her team consisting of Sarthak, Asad, Aridman, Ananya, Ujjwal, Shivani, Ayush, Dakshita, Kinjal, Nidhi, Shivendra, Priyanshi, Arshita, and Aisha. So I thank all of them for doing a lot of hard work in organizing this, right from the social media platform to organizing this event and making all the arrangements. Thank you very much. And once again, I welcome you all in this today's inauguration program. Thank you very much.
Thank you so much, sir. I would now like to invite our center coordinator, Ms. Madhura Vaid, to share with us the vision, the mission, and the modus operandi of Chanakya Centre for Alternative Dispute Resolution. Please, ma'am.
Hon'ble Vice-Chancellor Justice Mridula Mishra, ma'am, our Chief Guest Advocate Ratan Singh, sir, Faculty Coordinator of the Centre Shikesh Manu, sir, faculty members of the Centre, Sushmita ma'am, Kumar Gaurav, sir, Vijayan, sir, and all the members of CCADR present here, and all the attendees of our inaugurated session. Good afternoon to everybody. I'm Madhura Vaidya. I'm a 5th-year student at the university. I'm the student convener of the center. I'm here today to talk to you about the objectives behind the constitution of the center and our vision for its functioning and our initiatives and plans for the future. Our principal objective behind establishing this center is twofold. Firstly, developing a culture of research among the students of the university and in general universities. And secondly, engaging with various stakeholders in the field of ADR, including the government, community, and other professional entities such as law firms and other law universities. For these overarching objectives, we plan to conduct certain research, training, and publishing activities. Some of those activities include, firstly, that we recognize it is extremely important for law students to participate in and contribute to the body of knowledge. Considering ADR is a novel and upcoming field of law, the opportunities in this for research in this field are emerging. Through the center, we aim to facilitate this process for the students in the university in CNLU to firstly engage with the subject and subsequently carry out their own research in the field so that they can contribute to the field per se. We plan to do this through conducting guest lectures such as today's lecture series for in-depth discussions on a particular topic and workshops for students. Through these initiatives, we hope to expose students of our university to the career landscape as well as the specialized areas of the field of ADR. Secondly, we also recognize that a university exists within the context of a community and we have a responsibility to engage with that community in various fashions. Therefore, we plan to collaborate with various governmental agencies such as Ministry of Law and Justice in order to aid and advance the work of these agencies and contribute through our students and our actions of the center. Additionally, in order to facilitate the creation of substantial body of knowledge in this particular area, we plan to publish research material regarding the field of ADR through online media as well as through a journal. For this purpose, we plan to host a website for the center which would be a comprehensive look at the current happenings relating to the field and would publish and disseminate policy analysis, opinion pieces, and other material regarding the subject of ADR. We believe that the doctoral research and theoretical knowledge of the subject must be accompanied by an idea of the industry and what is required, what skills are required to actually succeed in this industry, and the technical know-how that is required to actually go ahead and practice in this industry. For this, we plan to conduct workshops and training sessions and collaborate with different law firms as well as practicing lawyers so as to we can contribute in training upcoming advocates and students in this particular field and impart knowledge in this area. Through all this, the CCADR aims to enrich both students of the university and from those outside, along with achieving the primary goal of positively contributing to the subject matter at hand. The center is blessed with our Vice-Chancellor ma'am as patron-in-chief, our Registrar sir as our patron, and Mr. Rishikesh Manu sir as the faculty coordinator. We also have Kumar Gaurav sir, Sushmita ma'am and Vijayan sir who our center coordinator, Rishikesh Manu sir, has welcomed before as faculty members of the center. Aside from me, the functioning of the center is looked after by two co-conveners, Ujjwal Singh and Aridaman Raghuvanshi. Both of them are here with us today. And aside from that, we have in total 12 members of the center. It is a privilege to hold this ceremony in presence of our Honorable Vice-Chancellor Ma'am and our Chief Guest, and for faculty coordinators and all the faculty members. Once again, I welcome you all and thank you very much.
Thank you so much, ma'am. I would now like to request our Honorable Vice-Chancellor, ma'am, Justice Mridula Mishra, to enlighten us on the importance of ADR in the present judicial system. Please, ma'am.
Thank you, Nidhi. A very good afternoon to all who are present on the screen and who are behind the screen but participating in this inaugural ceremony. First of all, I welcome everyone present and participating in today's inauguration ceremony of Chanakya Centre for Alternative Dispute Resolution. I especially welcome Mr. Ratan K. Singh, Senior Advocate, Chief Guest of today's program, who is going to address the session on a subject like career in arbitration. This subject is very important and useful for the law students thinking to join either litigation or any other field, maybe this corporate or anywhere you will go, the government or the politics, everywhere, because settlement and resolution is very necessary throughout everyone's life. So disputes are there, but how to resolve those disputes amicably, that is very important. And being a renowned arbitrator, so I'm waiting that he will give some tricks to our students that how after joining in the litigation they can go for the arbitration, which is the new field and most looked after field. Alternative dispute resolution, or as it is more commonly known or named, is now appropriate dispute resolution, is the practice of many ways whereby legal disputes and transactions are handled, managed or resorted. We can say that alternative dispute resolution is both oldest and the newest way for of resolving the conflict that has legal implications. As long as there are people on this earth, the dispute will be there, and we all will have to search for and look after for the better and new ways of resolving those disputes. And alternative dispute resolution was always there, but now it is more looked after because the situation has come like this when our courts are burdened with more than 2.5 crores cases. At all levels, the cases are pending. I know when I was an advocate and I joined this practice in a circumstance when actually I had never intended that I will join the practice or do anything. I was very happy being the housewife and looking after my household affairs. But the circumstances came like this that I decided to join the practice, the office in which I joined there before my joining. So the cases relating to first appeal, second appeal, criminal appeals which had been filed, they remained pending when I joined as an advocate and when I was elevated to as a judge. Even then those cases were not resolved. And what happens? That you file a person files a case. The case is pending for years together. In the meantime, he dies. And the second generation, they are not much interested in that dispute. that dispute becomes like a burden on the family. No one, the advocate who has signed the case, it is burden for him also that on each and every date he will have to appear without any fee in the matter, because the court will ask to appear the person, the advocate who is representing the litigant. So this is the affair in the civil courts, in the criminal courts, in the revenue courts, everywhere. Consumer forum was established that this will give a speedy justice to the persons, the consumers. But what is happening? Now you go in the consumer courts, there also the matters is pending for years. So all this situation can be improved, or some resolution can be brought to this problem only when the matters are resolved amicably. Because if we follow the procedure, the formalities and everything inch by inch, then I'm sure, and I have witnessed, I am the party of this, that the case will also move inch by inch, and it will not reach its destination for decades together. So the situation in this our country has become so that if so many cases will remain pending in the courts, so what will be what it amounts? It amounts the failure of the administration of justice. The justice delayed is justice denied. This is the maxim we all know, and we know what is its implication. Implication is that if today I have some problem or some dispute has arisen regarding my property, regarding my anything, and I have not got the solution immediately, then after 10 years, situation will change, everything will change. So if after 10 years that matter is decided by the court, then this will not have any effect. So for which I had actually filed the cases. So we know that the alternative, I have said that it is the oldest as well as the newest form of the resolution resolving the dispute, because it is nothing new. In alternative dispute resolution is not something which is very new. It was there always. Even in the Vedic period, there were the disputes were being resolved by some elderly person in the village, or the village chief. They used to decide, and that people used to follow that. Even in the Muslim era, this alternative resolution was there. But when this British government came and this colonial government also, it was there. The ADR was in existence before the modern justice delivery system was introduced by the colonial rulers in order to meet the demand for speedy and substantive justice to all. The government of India constituted Justice Sudhir Ranjan Das Committee in 1949 to look into the problems of delays in disposal of cases. The committee submitted its report in 1951 and recommended the curtailment of appeals and revisions to reduce the backlog of the cases. But I don't think that these appeals and revisions were curtailed, because I know whenever any case is filed, any matter, any order is when passed by the court, one or other party goes in either in revision or appeal as per the statutory provision available to them. In 1951, the committee made a recommendation, and thereafter, again in 1972, Justice Shaw Committee was constituted to report on the arrears in the High Court. In addition, Law Commissions also submitted 12 reports on the issue of arrears in courts, and several solutions were introduced. And in the year 1989, the Government of India, on the advice of the Chief Justice of India, constituted a committee known as Malimath Committee. The Malamuth committee made some recommendations, and thereafter, on the basis of his report, a meeting of law ministers took place in 92-93, and thereafter a joint conference of chief ministers and of the state and chief justices of the high courts was held, and it resolved that taking advantage of the ADR, the ADRs can be decreased in courts, and as it provides procedural flexibility and also saves valuable time and money, as well as avoid stress of conventional trial. Legal Services Authority Act was enacted in the year 1987, and this Legal Services Authority Act was enacted in view of the Article 39A of the Constitution, which obligates the state to provide free legal aid through suitable legislation or schemes or any other way to promote justice on the basis of equal opportunity. The Constitution of India, through Article 14, guarantees equality before law, and equal protection of laws. Article 39A mandates the state to secure the operation of the legal system and promotes justice on the basis of the equal opportunity and ensures that same is not denied to any citizen by reason of economic or other disabilities. The expression access to justice focuses on that the system must be equally accessible to all, and it must lead to results that are individually and socially just. We all know that the poor person living in the villages, most of them are uneducated and ignorant of court's procedure. They are always terrified because they don't know the procedure. They don't know the language in which the cases are being conducted in the court. So they are totally depending on their advocate, whatever they make them understand, they understand. And this amounts to confusion to the general people in the country, and the most citizens are not in a position to enforce their rights, whether constitutional or other legal rights, which in effect generates inequality. Considering all these situations, the former Chief Justice of India, Sri Deepak Mishra, while delivering valedictory session at the National Conference on Initiative to Reduce Pendency and Delays in Judicial System, has said that the issue of pendency and delays in the justice delivery system needs to be tackled with judges taking up the burden of judicial leadership and managerial skills. He further said that the discussions witnessed and emphasized on technological aspects and introduction of the best practice in the There are many ways and practices which relates to ADR. One of them is Lok Adalat. The philosophy behind the establishment of permanent Lok Adalat is that the court takes themselves in the role of counselors as well as conciliators. This experiment was very much in practice for some time, because at that time all the judicial officers at the district level, they had to conduct the Lok Adalat every Saturday, and lately it became very burdensome because pendency was the time which they could have actually invested in their courts, that was being spent in the Lok Adalats, and most of the time the Lok Adalats were, I think, not successful, because I was also the chairman of the High Court Legal Aid Committee. And many a times I also organize the Lok Adalat, especially in those Lok Adalats. The advocates were asked to bring submit their the consent that they are willing to this resolution of their cases by way of this conciliation, mediation, or but most of the advocates were not ready. What is their mindset? I don't understand. They think that if the cases are resolved very early, so they will lose their cases, and that will have some effect on their earning and income. And that was the reason that only such cases were decided in the Lok Adalat, such as the motor vehicle accident cases, where the compensation was not being paid to the person, the family members of the person who has died in the accident, and the insurance company, where they were forced to come and get this compensation amount paid to the family members of the person who has died during the accident. The permanent Lok Adalat is, in a way, I think that this is a good way for alternate. It can be taken as a good way to provide statutory forum to litigants to go prior to this. There is also in the Lok Adalat there was also provision to, before filing the cases, they should come and there should be pre-mediation, pre-conciliation between both the litigants. And if the matter is decided there, then the matter should not go, it should not be filed in the court, and that this will result into less burden on the courts. When I was a High Court judge, a judge from Australian court, Australia High Court, he has come. When I asked him that how many cases are usually brought or listed in his court, he said maximum 4 to 5 cases. And the number of the pendency in the courts, that was also we feel ashamed to disclose that what is the position in our courts. If you all have seen the list of the High Court, then you will find that if a judge continues to sit in the court from morning till late in the night, every day, even then he or she will not be able to actually finish the matters which are pending, which are listed before the judge. Why this is that? There are so many reasons. New enactments are there. For every enactment, the number of cases are filed, number of judges are not there, number of courts are not there, same judicial staff, same infrastructure is being used for the new litigations, the new matters, and that is the reason that arrears is piling up and piling up. If this condition continues for a more longer period of time, then the people's faith in judiciary, that is going to be affected. ADR, what is the need of the ADR for the present judicial system? For that I can say that first is that the arrears which has accumulated in our courts, that has to be for lessening that arrears, the ADR is the only solution. Secondly, enactments, new cases are coming. The nature of cases are changing. So far as our civil courts are concerned, the procedure where that is there in the civil court and in the civil court is concerned, that is not sufficient to meet the new demands, new enactments, new laws, new situation prevailing in the society, and the new problem which is emerging every day before the persons living in this society. A commercial, you see that after this, the world has now, you can say that we are living in the globalized world. Economy of one country is depending on the economy of the other country. Though there are this international trade, merger, business, or so many things are coming. For all those things, the civil code procedure, if followed, then I don't think that the matters are going to be resolved anyway. And if this will remain the situation, then our economy will also not progress. And the people living in other countries, the international market, the international traders, they will not find that in India there is ease of doing business. And for that, this is necessary that the time, if any dispute arises between one or another, one country or another, the traders, the business persons, the investors, then if their problem is not solved within a shorter period of time, then they are going to lose their interest in doing business in our country. For that also, it is necessary that the matters should be resolved by way of alternative dispute resolution. In the Commercial Courts Act, one of the chapters is that litigation mediation. So this has been done just to make this the speedy justice, speedy disposal of cases, speedy disposal of the disputes. So that is the reason. I have my, when I was an advocate, for some matrimonial matters, I used to go in the civil court also. I was very insistent that the matter should be decided in between the parties by way of conciliation. The other side of the advocate of other side, I requested him so many times that so you actually say you should suggest your client that conciliation is the best way for resolving the dispute. Both of them are young. If they will continue to fight for longer period of the time, so they will actually destroy their valuable period of time. They are now, at present, they are young, and by the time their dispute will be resolved, they all become old. So they have lost everything is that. And the advocate's reply was, you have so many cases, you don't know, but I have this case. I don't want that this matter should be decided earlier. This is the mindset of the lawyers that has to be changed. Because if it is not changed, then our judiciary is not going to breathe in a better environment where things, these matters are decided earlier, where the people get the dispute resolved in a shorter period of time. And so far the arbitration is concerned, and Mr. Ratan K. Singh is a very renowned arbitrator. It is said that arbitration is the best way of resolving the disputes where the high stake are there, or the internal or international matters. It is also said that it is inexpensive, but I think that it is not now inexpensive. The way fee is being charged by the arbitrators and the advocates, that is more expensive than the litigation in the courts. That for that, the schedule, there is a schedule provided in the in the amendment which has been brought in 2019, but that is not being looked by anyone, that is not being considered by anyone. So if arbitration is very good, because a third party resolves your dispute without going to the court. That is there. But here now I see that the arbitration is also becoming like the civil court practice. Day after day, the dates are date after date after date. It is neither being resolved in a shorter period of time, neither it has remained inexpensive. Mr. Ratan K. Singh he may have some reservations so far my views are concerned, but I have found that this is the reality. Mediation and conciliation, these are also mediation. That conciliation is the practice which is actually being practiced in this Industrial Disputes Act, where the workman and the employer they find it is a very easy way, inexpensive way, where their disputes are resolved in a shorter period of time. and conciliation is being utilized there very, I think perfectly it is being utilized as so far the Industrial Dispute Act is concerned. There are so many matters which are very short matters, very small matters. But once it is filed in the court, then when this number of that case will come, and for that the matters remain pending, the landlord-tenant matter. The landlord is not willing that the tenant should continue. That matter can be decided amicably. But it is not being done. There are so many procedures, section 15, section 16, section 12, all matters for everything. There is an order passed, and against that order, the matter will go up to the Supreme Court. Then again will come to the lower court. This is being done. So why, the question is why there should be, why that in alternative dispute resolution is a need for the present judicial system. My first answer is to lessen the burden on the judiciary, to free the docket of the courts. Secondly, the person actually whose interest is involved in the litigation dispute, if they are not knowing that what is happening, so far the alternative dispute resolution is concerned, this is an informal way of resolving your dispute. There they participate. They exchange their views. Most of the time the matter is settled in an amicable environment. There is no one is losing, no one is winning. Everyone is satisfied that situation has been, the problem has been solved. One more thing is that no one wants that if I have a dispute, that dispute should continue throughout my life. So shortening the period, that is also very necessary for deciding the dispute. And the most important is that the nature of the litigation is changing. But there was a time when there was a princely estates or the zamindari, then the nature of the dispute used to be the property matters, the inheritance, all these matters. After zamindari abolition, I don't think that anyone has that much of the land for which he will continue to litigate for years and years together. Now we are living in a commercial era, and in the commercial era, everything should be quick. If you want a better return of your business, then everything should be quick. If it will continue for a longer period, then the things will not be profitable for either of the parties. Thereafter, you see that so far the criminal matters is concerned. In the criminal matters also, the nature and the character of the cases have completely changed. There was a time when people, this place of occurrence was very was important. Now a person sitting in other country, the cyber crimes are being committed. Where is the place of occurrence? Where is the person? So nature of this cases, dispute, crime, everything is changing. And with all these things, it is also necessary that the system to resolve all these matters should also change, and we have to keep a pace with the changing time, and for keeping pace with the changing time, the changing nature of the cases, the changing problem, alternative dispute resolution is our destination at present. But for that, it is also necessary that we should have faith that whatever will be the result of this resolution, that will be similarly important as the decree of the court. If this faith is not there, then no one would like to go for the alternative dispute resolution. And so far, this establishment of this Chanakya what is the, I'm forgetting the name, Chanakya Centre for Alternative Dispute Resolution. I have great expectations, and I thank the students very much because they have taken so much pains for establishing this center. I also thank Rishikesh, Manu, Kumar, Gaurav, Vijayant, and every faculty members whosoever has participated in it. I was thinking for so many, for a long time I was thinking that Chanakya National Law University needs this center. And this center, because the students who are going to pass out from our institution, we have to prepare them for the changed environment in the legal system, in the judicial system. And that change, for those change environment, it is necessary that they should be more acquainted with the alternative dispute resolution. When we studied law, then there was nothing like alternative dispute resolution. There was no paper. It was not included in the syllabus. And for the first time, it's important. In the Patna High Court, I felt when our Chief Justice, one of the Chief Justice came from Gujarat, he was great believer in the alternative dispute resolution, and he introduced so many things. And so far I am concerned, after joining my practice, I had always been member of the legal aid committee, legal system, or everywhere. Bihar State Legal Services Authority, the Patna High Court Legal Services Committee. So I had interest in the alternative dispute resolution. I had this given as an advocate. I have decided, I have taken so many cases as a legal aid, and I had never accepted a single penny, a single fee, whatever is statutorily payable to me, that also I never claimed. So I wish all the students great success. So far they have established this center, and the objective which is in front of you, that must be realized, and you will have to make great effort for all these things. And I'm eager to hear Mr. Ratan K. Singh, that how the arbitration can be a very good very good for the upcoming lawyers to adopt as their career. Thank you very much.
Thank you so much, ma'am, for your insightful words. It's an honor to have you as our patron-in-chief, and we hope that under your guidance, our center would contribute substantively in the field. Moving forward, today I have the privilege of welcoming our chief guest of the event, Senior Advocate Ratan K. Singh, sir. Sir is one of the leading arbitrators and counsel who is appointed and engaged in complex, high-value commercial litigation and arbitration. With about 25 years of experience, he has a heavyweight practice in India as well as internationally, with specialties in construction, engineering, infrastructure, mining, and general commercial and civil disputes. Further, Sir is the only Indian to receive a fellowship from International Academy of Construction Lawyers, IACL, following his election by existing IACL fellows, recognizing his reputation in the field of construction law. Sir, we are honored to have you today with us. I now request you to enlighten us on the realm of career in arbitration. Sir, please. Sir, you're on mute.
Am I audible?
Yes, sir.
Thank you, Nidhi. Thank you for kind introduction. Madam Vice-Chancellor, Honorable Justice Mrs. Mridula Mishra, Mr. Rishikesh Manu, Faculty Coordinator, Mr. Manoranjan Srivastava, Registrar, Madhura Vaidya, a student convener. Ayush, member of the Chanakya Centre for Alternate Dispute Resolution. Good afternoon, and I must thank the organizers for having me for this event. I was going through the objective of establishment of the center. Objective says that it is started to promote academic research, develop ADR culture in the university, facilitate skill development amongst the students. I would say that we have numerous centers like this in many national law universities in India and all across the globe. What I would urge the founders of this center and the patrons of the center, namely the Vice-Chancellor, Mrs. Mishra, and the faculty coordinator, to take it to yet another level. This center should not confine its activities only to the universities and for the university students. It should also be an institution to promote awareness about arbitration, if I may confine myself to arbitration. It should take it to next level. It should make this center a center of excellence, center of knowledge, promotion of knowledge for other stakeholders such as judiciary, the State Judicial Academy, bar associations, other law colleges in Bihar and outside Bihar, as well as the industry associations. I come from Bihar. I had my initial education in Bihar. I was in Patna Science College. Thereafter, I did my LLB from Campus Law Center, Delhi. And then I've always practiced in Delhi. In fact, I never had occasion to do a single case in Patna High Court, though I have been going to all through the country and outside country. But what I know about Bihar is that we do not have visible arbitration culture in Bihar.
Yes.
Secondly, we do not have any prominent arbitration institution in Bihar. I think this center should become a torchbearer for creating awareness amongst all stakeholders, including the people who matter in the government. I had few arbitrations where I had co-arbitrators who were retired IS officers who sat with me as my co-arbitrators in large-scale construction disputes. I could see in their eyes this desire to have better arbitration culture in the state of Bihar. I'd urge all of you to make this center so visible by organizing international conferences. I would say, don't think that this center is meant only to cater to the need of your college. It has to transcend your boundaries. And whenever you think about organizing events, conferences, the symposiums, the workshops, moot courts, always think big. Think about organizing international conferences. Think about organizing international moot courts. Think about organizing such international essay competitions. I'm associated with multiple such activities in India in my different capacities. I'm the founder and chairman of Society of Construction Law, which is world's most prestigious construction law and construction arbitration body, which promotes education in construction law and construction arbitration. And in fact, I must say in the very beginning, teaching is my first passion. Advocacy comes next. So I travel all across the globe. I have spoken in almost all national universities in India and abroad, including Harvard. My experience tells me that any initiative taken by even a handful of people anywhere, if done with big heart, can really take you very far. Organize international conferences in CNLU, and you can count on me. I can at least assure you, you will have the top class international arbitrators, professors, and international arbitration practitioners. I'll have you for them. I organize India's biggest international conference on construction law and construction arbitration. Next is happening on 10th to 12th of December. Last was in 19. It is biannual event. And I had speakers from 32 countries. And I had 13 judges, foreign judges and Indian judges. I would urge you to make this center such a powerful center that sitting in CNLU, you can really create a buzz internationally. Create international moot court. There are 2 moot courts which happen in my name, and they have become international moot courts in very short span of time. I would say create international moot courts on the scale of West Vienna or West Hong Kong. It is doable. It is doable because you are an institution, you have committed people, and you have patronage of such a luminary like Mrs. Mishra. I have heard her, and I must say, I haven't heard this kind of talk for long, madam, I must say this. And I must assure you, in whatever capacity you want me to be there with your center, with your college, I'll be there. Lots of institutions and national universities are asking me to have to take classes for credit courses for construction law and construction arbitration, or for that matter, international arbitration or arbitration. I'm one of you. You can count on me. What I want to say you is this. There is another institution which is world's most prestigious arbitration institution in world, that is called Chartered Institute of Arbitrators UK, which has branches all across the globe, almost in 120 countries. This is the only institution in world which gives world-class accreditation to arbitrators and arbitration professionals. Chartered Institute of Arbitrators, and in fact, I am their director in India for last 12 years. And I have trained hundreds and hundreds of lawyers, professors, and other stakeholders. I am there with you, ma'am. I am there with you, the center coordinator and the students associated with the center. I straight away come to the topic, which is career in arbitration. And I wish all the very best to this center. And I'm very hopeful that the center, in the able guidance of Vice-Chancellor Madam Mishra, is really going to achieve great heights. Now, coming back to the topic which has been assigned to me, that is career in arbitration. If I have to talk about career in arbitration, I'll have to talk a bit about arbitration. Somehow my sense is that generally arbitration as a concept of dispute resolution mechanism is not understood properly, in fact, by the real stakeholders, and most of them. And please pardon me for saying this. I have heard what Mrs. Mishra said about this. Is it cost effective anymore? This is what Madam Mishra asked me a question. Is it really taking care of delays? Let me take this concept of arbitration in a right perspective. Arbitration, and very well said, Madam Mishra, that alternate dispute resolution process was there before litigation started. It was there, it has been there, it continues to be there. In fact, Madam Mishra also said that it is no longer alternate dispute resolution mechanism. It is rather appropriate dispute resolution mechanism. I would say it has always been appropriate dispute resolution, ma'am, and you're very right in saying what you said. What I say is this: before a state monopolized the justice dispensation system, it was private dispute resolution mechanism in place in all society, as you rightly said. After a state monopolized justice dispensation system, people started thinking that anything which is not happening inside the courtroom is alternate. And then when we saw the ills and the problems with the court administered justice delivery system, then we started giving more emphasis on other alternate mode of dispute resolution. May I say this? Arbitration, to be very precise, is not only about cost-effective and time-effective dispute resolution mechanism. There are many jurisdictions where arbitrations take more time than court litigations. And when we talk about arbitration, we talk about large-scale disputes. Parties are generally not bothered with the cost involved. What they're bothered with are A, B, C, D, which I may cover in a couple of minutes. The efficiency of dispute resolution, efficiency of quality of the dispute resolution or the decision, quality of decision. They are more concerned with specialized decision makers. They are more concerned with confidential and private dispute resolution mechanism because they don't want their dirty linen to be washed outside and in the open and the courtrooms. Parties want flexible process. They want to have autonomy of the parties. These are the hallmarks of arbitration. Now, Madam just talked about the Commercial Courts Act. If we look at Commercial Court Act, one emphasis has been given to something called case management. Let us try to understand where from this whole concept of case management came, and then let us contrast this with the arbitration as a dispute resolution process. In civil legal culture, as opposed to common law legal culture, in civil law or civil legal culture, civil law legal culture, or civil law countries like Central Europe or the continental Europe or the Latin America, Japan or China, even the Nepal, we all know they follow inquisitorial process as opposed to the adversarial process in common law culture. Now, when we talk about this case management, this has been taken from civil law culture, where judges are in charge of dispute resolution and decision making. Burden is on the judge to see that dispute is properly decided. That concept was brought in the English judicial system First by Wolf Committee, and thereafter taken forward by Sir Rupert Jackson's committee's report. It was incorporated in their CPR, that is Civil Procedure Rules, and now we have brought it here in India in this process, in this Commercial Courts Act. What is this case management? Case management process, which is to be undertaken by the judge concerned, is a process where judge takes charge of the proceeding, sees what all is happening, see how, and he has to see what all has to happen as per the requirement of this particular case, so that efficient the decision making happens. Unfortunately, though we have got Commercial Courts Act, though we have case management processes as built in the Commercial Courts Act, but again, it is not being applied for the reason which Madam Mishra talked about, Madam Vice Chancellor talked about, that we do not have adequate number of judges. Docket is so heavy, Madam knows more than me. So though you have procedures in place, but it is not happening in courts because judges do not have that much time. In order to have a proper case management, judges must have gone through the file, page by page, to understand what are the real disputes, what all has happened, and what is the way forward. Do we have that much time with our judges? Answer is no. And this is where arbitration comes in. Arbitration in another way is all about proper case management. You have one civil procedure code which applies to all disputes all across the country, for all types of cases, for all parties. However, in arbitration, you have tailor-made procedure which is to be agreed by the parties and failing which to be agreed by the arbitrator. So, proper case management happens there. Arbitrator knows and is supposed to know from day one what are the disputes between the parties, what is that party's position, parties are taking position on, how it is to be taken forward. So therefore, arbitration is a process which is private. One judge made for one case, that judge is supposed to know all the disputes, all the contours of the dispute. The judge, the private judge called the arbitrator, has to decide what is the right procedure, because he is not bound by Civil Procedure Code or Evidence Act. He is concerned with proper dispute resolution. So one CPC for one country, for all kinds of cases, everything is gone. So one judge, all procedures, private judge, all procedures which he thinks is appropriate, he can apply for that particular case. And that is why people go to arbitration. That's why people go for arbitration, because parties can decide the process. Procedures are to be decided by the parties. So parties can say, we want cross-examination. We do not want cross-examination. We want discovery. We do not want discovery. We want interrogatories. We do not want interrogatories. We want to file witness statement or evidence by affidavit. Yes, no, don't do this. We want to have only document alone arbitration. Do that. If every order passed by the arbitrator till the award is passed should be shared with the parties. Yes. We want to sit in evening. Yes. We want to sit in morning. Yes. We want to sit in hotel. Yes. We want to sit in any room of any of the parties. This is what is flexibility. This is what is autonomy of the parties. This is how it is tailor-made process. This is how it is in closed door. Can a party? I was doing one arbitration in London. It was under ICC rules. It was seated in arbitration. We used to go with my team and go to do cross-examination and arguments. And after I had my interim award, other side came down to India, paid multiple times than what they had earlier agreed, for two reasons. One, that they had seen what was argued against them, and other, they said, we do not want that this award should go in public domain. because it will really compromise with their credibility in international market. So no party wants, no business entity wants their business secrets to go out in the market, in the world. That's why arbitration. So I know we cannot go on and on with the arbitration as a concept. I'll just try to define the arbitration. Interestingly, there is no definition given of arbitration in Indian Arbitration and Conciliation Act, or for that matter, in any legislature anywhere in world. For obvious reasons, sometimes definitions given creates more problem than it seeks to answer. Though I'll try to define the arbitration in a simplest way, that arbitration is a private dispute resolution process where decision maker is a private judge who decides the dispute as per the procedures agreed by and between the parties, failing which he decides, and his decision of this private judge is final and binding on the parties. And that is called award. An award is much more powerful a tool than a decree of the court, because decree of the court can be challenged on facts and law, on law and facts before first appellate court and before second appellate court on law. You can go on and up to the Supreme Court. But whenever you have an award cannot be challenged on facts as well as on law. It can only be challenged on two broad grounds. One, it is against the public policy. Second, there was violation of due process, or in other words, principle of natural justice. So therefore, it is said very famously, arbitration is a one-stop shop, no second chance. And that is why comes the importance of centers like this, which would help in producing efficient arbitration lawyers, arbitration professionals who would know from very beginning of their career what arbitration is, what are the importance of this. When I say one-stop shop, it means that you have one chance before the arbitrator to give your best. You sink with it or float with it. You have no chance to improve your position before court of law in the challenge to award or in the appeal under section 37. This is one-stop shop. Therefore, arbitration is a serious business. No further chance. And that's why it is said arbitration is as good as the arbitrator and as good as the other stakeholder. So that is why the quality of lawyers, arbitration lawyers, quality of arbitrators are of great importance. In fact, recently I was speaking in London, and there I only talked about this concept that arbitration is as good as the arbitrator. Now, I would urge all the students to define arbitration in their own ways. Do it today after today's talk, and do it after every 3 months. More you learn about arbitration, your definition of arbitration will keep changing. It will getting better and better and better. And that really keeps you motivating to study and know more about arbitration. Now, before I talk about the careers specifically, let us know what is the importance of arbitration for all of us, for all the stakeholders. Almost 60% of domestic commercial disputes are decided through the process of arbitration. And almost 95% of international commercial disputes are decided by way of arbitration. Now, question is, can any lawyer or budding lawyer or law student can afford to read and know about arbitration? Answer is no. Second thing, I must say that arbitration, if you know about arbitration, if you pursue arbitration, if you follow arbitration, it makes you a better litigator as well. And I'll cover this in a moment. It makes you a better litigator as well. Wherever you go, whether you are in an organization as the council of that particular organization, you are working in a law firm in corporate department, or you are working as a litigator, you are GC, wherever you are, arbitration is not going to leave you. Therefore, better you don't leave arbitration. And wherever I go and talk about career in arbitration, wherever I talk about arbitration, one question generally asked is, does it remunerate well? Does it pay you well? In fact, 3 days back, I was doing one arbitration. It is a infrastructure power plant arbitration, and more than $1 billion is involved in that, though it is a domestic arbitration. And one of my interns asked me, sir, how much arbitrators have been paid in this arbitration so far? And how much lawyers are being paid? So I just asked one of my juniors to calculate the number of hearings which had gone by now. So total number of hearings which have gone was around 64. And for 34 hearings, dates have been fixed because we are arguing finally. Now, 101 multiplied by conservative number, which is the least any arbitrator charges you, is 2 lakhs per 2 hours or 2.5 hours. So it was obviously more than 2 crore per arbitrator. We had 3 arbitrators, 6 crores divided by 2, because both sides will say that. And the lawyers who does these matters do not charge less than what arbitrators charge. So I can tell you, if you really aspire to be an arbitration professional, arbitration lawyer, good number is waiting for you. Good number is awaiting. And somebody, in fact, I was giving a lecture in CNLU sometime back, and somebody said, what if I have got interest in investment arbitration, are we paid well? I gave them example of UCOS arbitration. There, the award value was around 50 billion. And the counsel for the claimant was paid 90 million USD. And the lawyer for the state was paid 35 million USD. Now I leave it to all of you to put numbers after 90 and 35, and when your numbers are complete, you can discuss amongst yourself. It pays, ladies and gentlemen, it makes you international and global lawyer. It makes you think like a global citizen. It makes you think like a global and international dispute professional. Arbitration practitioners, arbitration lawyers, and students pursuing arbitration never and should never confine themselves only to what your Arbitration and Conciliation Act says and what your Supreme Court and High Court talks about. It is always comparative analysis you have to follow, and you follow the developments all across the world. So you can have comparative analysis of what is going on in different jurisdictions. And end of the day, it helps you even in your litigation. Let us talk about discovery, which is one of the method of discovery is discovery by way of production of documents. How do you do that? Very seldom it is used in the court litigation, though you have provisions in CPC for this. But if you do arbitration well, you know how to do it, and it is amazing tool for discovery of truth, discovery of facts. It helps you immensely. Now, for that, you may read IBA guidelines on taking of evidence, which is a soft law. I'll come to that particular topic, what all you should read. But before that, I would say it is amazing career option. Career, you can sit as arbitrator, and you can become arbitrator at any age. There were some restrictions brought, but that has been removed now. Don't worry, you can start your career as arbitrator at the earliest, at any point of time after you become lawyer. I started sitting as arbitrator at very early age of my career, though I was pursuing litigation as well. So I used to wear two hats. So I'll encourage all of you to wear minimum of two hats, as litigator and as arbitrator. Secondly, you can be an arbitration lawyer. Obviously, you can be a court law, the litigator as well. Arbitration lawyer, you can be arbitrator. Another career option is now lots of big organizations are looking for in-house arbitration counsels. That is amazing career option for many. You can opt for as case counsel with arbitration institutions in India and abroad. In fact, I remember having met many case counsels working with SIAC, Singapore International Arbitration Centre. In Kuala Lumpur, I have met lots of people who were working with AIAC, which was earlier KLRCA. So this is amazing career option. You can work as tribunal secretaries as young lawyer, and you get chance to closely work with top class arbitrators. You see how they think, how they decide, how they conduct the proceeding. Though in India, we do not have any institution which is running the course for tribunal secretaries. HKIC does conduct such courses. And so anybody having interest can really look at HKIC until you have an institution doing such courses in India. You can be international bureaucrat, like with Commonwealth. Commonwealth organization has lots of arbitration practices. You can be with WIPO, you can be with many other international arbitration institutions. You can be cited as experts, legal expert or industry expert. So there are multiple career options. As I said, everything comes next. It makes you a better legal professional. It haunts your skills, even as a litigator, because you are pitted against top class people, high stake matters, top class opposing counsels, domestic and international. This gives you, and the kind of literature you get to read. You do not get so much of literature about CPC. There are only a couple of books. Here you have multiple of literature all around the world. Read them and enjoy yourself with that. Now, question is what to all to read. First of all, Arbitration and Conciliation Act you have to read, but you have to also read the model law, ancestral model law, because your Arbitration and Conciliation Act is based on ancestral model law. Your Arbitration Act itself, it says in the preamble that it is based on ancestral model law. So you must read ancestral model law, which is the parent act for your act. Read them. In fact, when 1996 Act came in, it was almost verbatim reproduction of the Model Act. However, 2015 amendment has brought some changes, and 2019 amendment has brought yet another set of changes. But ancestral model law remains the parent act. Therefore, you should read ancestral model law. And if one has to understand and interpret Constitution, best way to understand about Constitution is to know the TRAVOX, that is the legislative history of Constitution. So that is the discussion in the Constituent Assembly. Similarly, if you want to understand your act, you want to understand ancestral model law, learn and get to know about the TRAVOX preparatories of ancestral model law. That is the legislative history, which is freely available for free on ancestral website. So whether it is ancestral model law, whether it is the TRAVOX, and there is something called CLAUD that is again available for free, that is digest of cases on arbitration, on the model law provisions, because model law, almost all countries today are model law countries. All countries are following, or sometimes they say we are influenced by model law. So once you know model law, once you know your Arbitration and Conciliation Act, you get to know arbitration legislation of almost all trading nations. That is such an amazing tool. So read that history, and then go further. Read 246th Law Commission report of under the chairmanship of Justice A.P. Shah, based which this 2015 amendments were brought in your Arbitration and Conciliation Act. You must read that. And going forward, you must read the report of high-level committee under the chairmanship of Justice Sri Krishna, B.N. Sri Krishna. So that committee's report was the Region Court 2019 amendment. And this committee's report really takes you to so many aspects of arbitration. This is an amazing piece of document you must read. In fact, when you read at page 3, you'll find my name, because I was also invited to give my presentation and give my thoughts on this. And I was asked to represent Chartered Institute of Arbitrators UK here before the committee. And I had suggested, if you want to improve arbitration in India, there is only one solution, that is training. I said 3. One is training, second is training, and third is training. Therefore, ladies and gentlemen, answer to all the problems lies in training, nothing else. Now, after you have read this ancestral model law, your act, Trav Hawks, Claude, the 246 Commission's report, Law Commission's report, and Justice B.N. Sri Krishna Committee's report, then you should also read ancestral rules. Ancestral rules are models. It is different from ancestral model law. It is rules. So rules are essentially model for ad hoc arbitration. How ad hoc arbitration should be conducted. Anybody who wants to understand how ad hoc arbitrations are done and should be done, they should simply go to this to have it as a model, as a standard. Obviously, you are free to make changes as much as you want. However, you have something to look at. So anybody who is at loss to understand how to conduct arbitration, as a new arbitration lawyer, don't do anything. Go to ancestral rules, equip yourself with that, and you will come out as a good arbitrator and good arbitration lawyer. Apart from this, I would strongly encourage all of you to read rules of one popular arbitration institution. And I'm giving you 3 options. One is ICC rules of ICC Paris. Second, SIAC, rules of SIAC, Singapore International Arbitration Centre. Or third is LCIA, that is London Court of International Arbitrations. There are multiple. You can read the rules of HKIC, you can read the rules of AIAC, you can read of even the MCIA in India. But I would say read the rules of ICC or SIAC or LCIA. This will tell you how institutional arbitration happens. What is institutional arbitration? Institutional arbitration is different from ad hoc arbitration. What is institutional arbitration? An arbitration which is administered by a permanent institution. So that is institutional arbitration. So you must know how institutions work and how institutional arbitration work. Therefore, I encourage you to read one of the 3 rules. And what you should also read is something called, as you have read Arbitration and Conciliation Act, this is called hard laws. These are statutes. These are mandatory. You have to follow this. There is something called soft law. Soft laws are not mandatory, but if parties agree to adopt them, then it becomes mandatory. And these are amazing literatures and documents which will really help you immensely in understanding the arbitration as a concept. So you must read, whenever you get time, all the guidelines and protocols of at least two institutions. One is IBA, that is International Bar Association, and second is CIARB, that is Chartered Institute of Arbitrators UK. And these all soft laws are freely available on their websites. So you don't pay and you get to learn so much about these soft laws. Now, I straight away come to, I will obviously encourage you to read the law reports, which really gives you tells you about the cases decided by the courts. You should also read good arbitration journals. And this is where centre should take initiative to come out with its own journals, peer-reviewed journals, world-class journals, and you should become pioneer like Jodhpur. I have gone and spoken many a times there. Jodhpur National Law University has an arbitration center, and their journal is very reputed by now. So why can't you have very reputed peer-reviewed journal, have top guys on the board, don't compromise with the quality, and take this mission forward. Now, there are few blogs which are freely available, like arbitration blog or by Kluwer. It is freely available, and sometimes, and you get interesting reads for free. Read them. And if it comes to books, now I'll suggest one of the three books. One is a student edition of the book written by Gary B. Ball, a student edition, paperback edition, or book by Redfern Hunter. Redfern Hunter is very popular book, particularly in this part of world as well as in UK. Very popular, very well written, amazing book. You can refer to that, Redfern Hunter's book. And third book in the alternative is written by Margaret L. Moses by Cambridge University Press. It is very popular book in US law schools. So you have to take a call. And if you ask me, you can go for either of the three, but my vote goes for Redfern Hunter, easily available, easily readable, easily understandable. Apart from this, you must attend seminars, conferences, webinars, workshops as much as you can. Because if you really want to be a good arbitration professional, you should be visible. You should network well. You should write blogs. You should write in journals. You should go for speaking opportunities. You should connect with people. Attend as many seminars and conferences as you can. And sometimes students ask this whether LLM helps. Yes, kids, it helps. Now, dual qualification is something which is really appreciated all over. Globalization is leading to an increase in the demand for international lawyers with language skills, cultural awareness, overseas experiences, dual qualifications, your publications behind you. All of this matters, because what is true in courts generally is not true in arbitration. Somebody will not go to you just because you are a very famous litigator. Unless you know arbitration, nobody is going to come to you. And this is where I take a pause. Just because you know the arbitration, again, that is not the answer to all the else and all the requirements of client. You must know the industry and the commerce well. If you want to go for construction arbitration, you must do construction industry well. You must know what are the standard forms applicable. You must know what are the typical disputes. You must know how disputes arise. You must know how disputes are answered. And before I go further, I must tell you a very interesting fact. That fact is that like 60% of commercial disputes are decided through the process of arbitration. Similarly, 60% of arbitration in India are construction arbitration. And 40% of institutional arbitration, as per ICC report, or construction, engineering, and oil and gas arbitration. So if you really want to pursue arbitration, this is one area, because you need to also think about a specialization. And this specialization, particularly in this area, that is construction arbitration, which constitutes almost 60% of arbitration in India, you cannot ignore. You should not ignore. But again, you must be aware that construction arbitration and construction law are different breed of animals. This is not just either, the construction arbitration is not as it is not simply commercial arbitration. Similarly, construction law is not only law of contract, it goes much beyond. It has its own very developed jurisprudence. Have started taking interest in that. And if somebody asks me what would be one book which I should read to understand construction law, then Professor John Off has written a very good book on construction law, very basic book. You must read that. That will really help you immensely. He is the member of Keating Chamber in London, and he's a professor. Professor John Off. That is one book you can read. And if somebody says, where can we read about construction arbitration? Then you will have to wait for 1 month. There is a book for which I have written on construction arbitration. This book is going to be published in a month's time by Thomson Reuters. There we have some chapters on different specialized form of arbitration, like maritime arbitration, construction arbitration, investment arbitration, and sports arbitration. So you can look at that. Now, do I have time, or I'm out of time? I must know this. Somebody has to tell me this.
So we have time.
Oh, sure. Oh, if I have time, then I'll take you further. How to start your career? Start at the earliest possible opportunity in your law school. Don't wait to become a lawyer. Participate in moot courts. And center should organize its own moot courts on arbitration. And whatever assistance you need, feel free, just let me know, I'm there with you. In every respect, don't hesitate. So start at the earliest. I have had interviews of many young lawyers who have just passed and come out from their law schools, and they really know well about arbitration. So where they learn this? Whether you have this curriculum or not, whether you have to write an exam on arbitration or not, you must follow this and follow well. Participate in moot courts, write for journals, write for blogs, go for speaking opportunities, and try to have internship or clerkship, judicial clerkship, or juniorship with arbitrators and arbitration professionals. And one important thing, try finding a mentor. He can be your law professor, he can be one of your seniors, he can be anybody else. Try finding a mentor. And how to further your career and make it sustainable. And as I said earlier, training, training, and training. And one very important thing, start whether you are in internship or you have just passed out of your law school. Develop this habit of reading the case files. Go for bulky case files. Develop this habit of go through bulky case files from page 1 till page last. Initial layers, it helps immensely. Start preparing list of dates and events, chronology of events. This is how you get to know the industry. This is how you get to know how parties interact with each other. This is how you get to know how parties take position and how disputes arise. And at later stage, one important thing is, and in fact, I would say from very beginning of your career, you must know how to manage facts. How to manage facts and how to manage documents. Arbitration is essentially about fact finding. So doing mastery of facts, learning the techniques to simplify the facts for your own consumption is an art which you have to learn from your seniors or work on yourself and develop this habit. Prepare chronology of events, list of dates and events, put documents together, then start having your own techniques, like start having issue-wise documents, blah, 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 because it requires a different different lecture for that. In fact, I do, last year I had done one workshop where I had given webinar of 7 days. There I teach for 2 hours every day for 7 days. So it is going to happen soon. So whenever it happens, I'll let you know. Another thing is, what are the attributes? What should be the attributes of a good arbitration professional? And start thinking of yourself from now as arbitration professional. Knowledge of arbitration law, that is the process, but domestic and international both. Don't think who is going to give me international arbitration cases. Don't think who is going to give me investment arbitration cases. Everything will fall in line. Create your own infrastructure, that is infrastructure of your knowledge of arbitration and different forms of arbitration. Advocacy skills, which includes oral skills and written skills. Language is very important. Work on your language. Try to make it better, better, and better. Now, sometimes this is a common question which is asked by law students: where from you get the work? What if I have to travel to a new city to which I do not belong? If I have to travel to Delhi or Mumbai or any other city, and I don't know anybody in that city, where from I get cases? Don't worry. I'm a first generation lawyer. I came to Delhi. I had nobody to look at. So only requirement is work hard, be consistent, and be honest to your file. Work every day and be honest to yourself and to your client. Whether client is sitting on your head or not, you must give your 100% for every case. And if you are ready to do that, which is very easy thing to do, then nobody can stop you. There is always dearth of and shortage of good lawyers, good arbitration professionals. Even today, whenever I have to do any international arbitration, and if I am not sitting as arbitrator and I have to choose international arbitrator from India, I am really at loss. We do not have good international arbitrators. Sometimes we do not find. There are few, but there's a lot of. We need much more bigger pool of international arbitrators, international arbitration lawyers. And in fact, I'm reminded of a very good saying of my father. My father used to say, there is always vacancy on top. In the pyramid, when you look at the top, when you go at the top, there is always vacancy. So good lawyers are always welcomed in any new city. Good arbitration professionals are always welcomed in any new city. Never ever think of all of this. This is all immaterial. Only thing you should think of is that I have to learn all requisite skills. I have to develop my knowledge. I have to create my infrastructure of knowledge and forget about money. Forget about everything else. Everything will follow you. Money will follow you and success will follow you. You need not worry at all. And last, something which is needed. Try to become member of young member at your age in your law school. Try to become young member of many international arbitration institutions which are offering arbitration institutions which are either administering arbitration or not administering arbitration. Whether it is CIR, Chartered Institute of Arbitrators, it doesn't administer arbitration in that way, or ICA doesn't administer arbitration that way, but they are offering young student membership which is for free. Go for that. CIAC offers this, ICA offers this. There are multiple arbitration institutions which offer young membership. Go for that. And thereafter, go for accreditation. And one institution of which accreditation is globally recognized is Chartered Institute of Arbitrators UK. And I am their fellow. That is the highest accreditation. If you are a fellow of Chartered Institute of Arbitrators, that is your complete introduction, not only in India, anywhere in world, wherever you go in world, nobody is going to ask you whether you know arbitration or not, because after your name, there will be suffix. That is, I use FCIAR or Nidhi FCIAR. And in order to achieve to that level, you have to have 3 levels of accreditation. First level is associate level of membership that even law students can do. Once you do this, and in fact, I have trained many law students, and the result, and I teach because I'm the accredited tutor of Chartered Institute of Arbitrators UK, and I have trained many students and lawyers, and the result which I have my students and the candidates have given is 100%. It is doable. All of you can do it. Write for ACR with JAM. And once you do that, they will provide you accreditation of associate, which you can use as a suffix after your name. It will appear on your signature, on your visiting card. There you write Nidhi ACIAR. And that in itself is a big accreditation. It is globally recognized. You go and see now in your library, all top authors of international arbitration or arbitration will have this suffix FCIR. So try to have that accreditation. That's really going to help you. And think like an international lawyer. Think big for yourself, think big for your institution. Thank you very much.
Thank you so much, sir, for your time and your words of wisdom. This was a very insightful session for all of us. With this, we have concluded all our events scheduled for today. I now invite my co-host, Dakshita Dubey, to give the vote of thanks.
Thank you, Nidhi. Good evening, everyone. I, Dakshita Dubey, have the immense honor of giving the vote of thanks for today's event on behalf of CCADR. Firstly, I would like to thank our chief guest of the day, Senior Advocate Chanakya Centre, sir, for taking out the time to share his knowledge about the avenues present for ADR in the legal profession. I would also like to thank our Hon'ble Vice-Chancellor, ma'am, who has been a big help in the establishment of the center. I would like to thank the backbone of our center, Mr. Hrishikesh Manu, sir, as well as Mr. Kumar Gaurav, sir, Mrs. Sushmita Singh, ma'am, and Mr. Vijayan Sinha, sir, under whose guidance the student members have worked so hard and because of whom the establishment of this center has been possible. Last but not the least, I would extend my warmest gratitude to the student members of the center. Right from designing the logo to sending out emails and finalizing even the smallest of the details for the successful completion of today's event, the student members have played a very important role in the event. I would like to thank the outreach team, the social media team, and the design team who have worked tirelessly under the guidance of our convener and co-conveners. Thank you, everyone. My heartiest thanks to everybody who took out the time to join us on our inaugural ceremony and made it such a big success. Thank you all for joining us. We hope to connect with you all again very soon. Till then, keep safe and have a good evening. Thank you.